Pennsylvania's own anti-Sharia bill and the larger movement of these anti-Sharia bills nationwide is that what is so disturbing about these cases is that they violate the Establishment Clause of the United States Constitution. I mean, that's the most obvious legal issue here. And a lot of people get sidetracked and they see this as a Free Exercise Clause case, which is the other religion clause of the US Constitution. And I say that they get sidetracked because what happens there is they start focusing upon what does this law do? What is this law? What is Sharia? How is Sharia lived in everyday life? And how does House Bill 2029 affect that practice? And that's really not the critical issue here. The critical issue is whether House Bill 2029 or other similar bills essentially serve as an official condemnation of the Islamic faith. If it does, it violates the Establishment Clause of the United States Constitution. And that is the strongest legal argument. I've spoken with many legal scholars on this issue, and the most obvious legal issue is that these bills clearly violate the Establishment Clause. So to understand the Establishment Clause of the US Constitution, you need to know that what the Establishment Clause does is it says that the government can enact no law that establishes a religion. It's not very clear on what that means. What is the establishment of a religion? So through United States Supreme Court jurisprudence, the court tried to define what that meant. So first they came out with this case called Lemon v. Kurtzman. And Lemon created what is now referred to as the three-part Lemon test. And under that test, a statute violates the Constitution when it has it survives constitutional scrutiny when it has a secular purpose or secular intent, and when it neither has the effect of neither advancing nor inhibiting religion. Now, that was a 1971 case. Now, some years later, in 1984, the Supreme Court decided the case of Lynch v. Donnelly. And Lynch v. Donnelly is actually, it's fascinating because it's not famous for the majority opinion. It's famous for Justice O'Connor's concurring opinion, which is fairly unusual in United States Supreme Court jurisprudence. And in that concurring opinion, she said, you know, I don't understand this Lemon test. It's complicated, it's confusing. I'm going to provide what she called an analytic framework for how to understand the Lemon test. And she said quite simply and succinctly that a statute violates the Establishment Clause of the US Constitution when it either endorses or disapproves of a particular religion. This became known as the endorsement test. And what's so fascinating about it is she says that the Establishment Clause can be violated in two principal ways. One is when government becomes entangled with religion. But the second and more direct violation occurs when the government commits an act which serves as either an official condemnation or an official approval or endorsement of a particular faith. And she further explained why this is disastrous and why this is significant. She said the Establishment Clause prohibits government from making adherence to religion relevant in any way to a person standing in the political community. Government can run afoul of the Establishment Clause in two principal ways. The second and more direct infringement is government endorsement or disapproval of religion. This is what's really critical here. Endorsement sends a message to non-adherents that they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the political community. Disapproval sends the opposite message. And that's really key and crucial, and that's the fundamental reason why these laws are unconstitutional. They officially condemn the Islamic faith. They tell Muslims, adherents of the disfavored religion, that we are not full members of the political community, we're not full Americans, and we don't deserve the same rights and equality as everybody else. For this reason, if House Bill 2029, others like it, really do nothing, if they're nothing more than a sheet of paper that says Islam is evil and so are Muslims, that law is unconstitutional for that reason. There is actually no worse thing the United States legislature can do to Muslims than to pronounce that we are an evil faith, that we are un-American, that we are not full insiders within the political community. So that's answering that piece. I've also been asked to explain what is the effect of this bill upon Muslims? How does it hurt the Muslim community? And really my answer goes back to the first. I mean, this is how it hurts the community. It tells us that our religion is disfavored, that we do not belong here, that we are not full Americans. And you know, I should point out that this is not an issue in which the United States federal courts have been silent upon, right? So this case is being litigated in Oklahoma. It was litigated in the U.S. District Court for the District of Oklahoma. It's also been litigated in the 10th Circuit Court of Appeals, the jurisdiction of which includes Oklahoma. And the 10th Circuit opinion really talks about, it focuses upon whether there's a justiciable issue of law, whether the plaintiff in that case, Amara Chaudhry, has standing to raise a claim. And really the opinion focuses upon whether he was in fact injured. And that was what the proponents of this bill, so the adversaries to Mr. Chaudhry, were arguing. They said, you know what, he hasn't really been injured. He can't point to any economic loss. Nothing bad has happened to him as a result of this. It's all purely speculative. And the 10th Circuit said, no, actually he has been injured. And again, I'm not supposed to do this, but I'm going to read from the court, because the 10th Circuit said this much more poetically than I ever could. They said, the reason why the Oklahoma Save Our State Amendment violates the U.S. Constitution is because Mr. Awad suffers from a personal and unwelcome contact with an amendment to the Oklahoma Constitution that would target his religion for disfavored treatment. And that's so critical, because that sentence explains exactly what's wrong with these bills. It's not that his marriage was invalidated. You know, he hasn't died yet. His will has not been probated as yet. It's the fact that he had a personal and unwelcome contact with a law that says his religion is invalid. That is the injury. That is what the district court held. That is what the circuit court affirmed. And, you know, and I just can't say it any more clearly than that. That is what's wrong with these bills. And, you know, most of the time in religion clause cases, that's all that matters. When you think about establishment clause cases, you think about a nativity scene in front of a courthouse. You think about a giant crucifix on public land. And that's all that happens. The persons of the disfavored faith say, you know, I had personal and unwelcome contact with that symbol. It disfavored my faith in that it favored another. And that's all the injury that matters. That's pretty normal. But our plaintiff here went beyond that. He said that this amendment doesn't just target me, it condemns my religion and exposes me to disfavored treatment. So that is the critical injury here. That's what's wrong with these bills, and that makes them invalid even if they did nothing. The reality is they don't do nothing. And that's why we see so many groups signing on with us to say that these bills are invalid. And the primary effect will be in the areas of family law. Specifically, marriages and related issues like custody and divorce, as well as the probation of wills. So I'm going to start first with wills. So Amara Chaudhry's case, a plaintiff in Oklahoma, he had a will that specifically referred to the Hadith, which is a religious document in Islam. And his argument was that because that will refers to the Hadith, it cannot be probated by the court. The courts will not see it as valid. The Oklahoma Save Our State Amendment accomplished that very end. It said that you can't look towards foreign law, so if somebody's will refers to the Hadith, that is foreign law, and it's specifically Sharia law, which Oklahoma specifically said was invalid, and thus, what happens to the will? Is it not probated at all? Is that section not probated? So that raises all these interesting questions, and why should this plaintiff have a will that's less valid than somebody else's? But then you have other contexts. What if people decide to get savvy about it and they say, well, I'm not going to reference the Hadith, I'm just going to incorporate these principles into my will? Well, then what's a court going to do? Are they going to try to look into it further because somebody has a Muslim name to see if it really is an Islamic will? and then decide not to probate it then? What if somebody does not incorporate Islamic principles at all, but they are known to be Muslim? Are the courts then going to say, well, I don't know, that's a Muslim person, maybe they got some Muslim stuff in their will, and so all wills of Muslim people are presumptively invalid because we might just sneak it in there? Those are the kinds of effects that happen. This is something that happens after death. This isn't even something you have control over. The other issue is marriage, and this is pretty huge. I mean, courts pretty routinely look to foreign laws in determining whether a marriage took place, was the marriage valid at the time it was entered into, the date of the marriage. So when a couple gets divorced, let's say that a couple is married in a Muslim majority country, they have their nikah, their wedding certificate there, they eventually get divorced in the United States. Most commonly, people look to that marriage license, that Islamic marriage license, to determine the date of the marriage for the purposes of dividing the estate, because you divide the assets accrued during the duration of the marriage. But you can see that it could possibly have other effects. For example, if a couple was never legally married, is the husband even presumptively the father of the children? You know, can he even claim custody of his kids, or does he need to establish paternity? So we see the way that these laws have effects. A very direct way would deal with things such as the demarcation of halal or kosher foods. So these are all the ways in which it affects the day-to-day life of American Muslims. But I still argue that the biggest way it affects us is it tells us and it tells everybody that we are not true Americans.